Welcome and thank you for attending today's session of Lexbe's eDiscovery webinar series, Best Practices Protecting Privilege, presented by Lexbe Principal Gene Albert, discussing the increasing challenge of maintaining the confidentiality of privileged case documents and data. Our eDiscovery webinar series covers a wide range of topics relating to how eDiscovery and litigation document management technologies can be used to improve review workflows and support case goals. Today's webinar should last about 20 to 30 minutes and will have a URL to access a recorded version of the presentation available to anyone who registered later this week. To give you a brief overview of our focus at Lexbe, we develop and implement technology that helps legal professionals meet tight discovery deadlines regardless of the amount of data in their case. We offer high-speed ESI processing and conversion services in addition to our web-based review tool, Lexbe eDiscovery platform. Lexbe has recently been named a top 100 eDiscovery provider by Complex Discovery. If during our webinar there are any questions that you have or any technical issues being experienced, please email them to webinars@lexbe.com. Before I hand things over, let me tell you a bit about Gene's background. As mentioned, Gene is a principal and co-founder at Lexbe and has a wealth of experience consulting on large-scale eDiscovery matters. Gene has also frequently contributed academic papers and commentary on a variety of eDiscovery and litigation technology topics. He's also an experienced attorney, having worked as in-house counsel as well as in private practice. With that, here's Gene with Best Practices Protecting Privilege.
Great, thank you, Stu. Well, this is a really interesting topic that I'm happy to talk about today. The agenda here, we're going to talk about the increasing risks of protecting privilege and logging, logging requirements, some of the headaches that have come up with email and dealing with those in privilege logging in recent years, issues of inadvertent release and waiver, categorical logging. Then we'll get into specific workflow and automatic logging included in eDiscovery tools, and how NearDup analysis can help on catching all versions of privileged documents, and end it with some tips and recommendations. If anybody has any questions or comments, I welcome them, and my email is gene@lexbe.com. Let's jump into it. Why are there more issues with privilege logging today than there were in the past? Well, the main reason is just more data. So there's a lot more data being captured, and that means that there's more privilege information as well. So we continue to see the amount of data go up at almost exponential rates, and cases are getting bigger and bigger. So we need to have better and better tools to deal with all types of ESI, including privilege information, as there's not particularly more money or more time. So everything needs to be more efficient now. There's some specific things that have increased risk in privilege review. First is that there's just more documents, that I just mentioned. Second is that often we're using keyword search or technology-assisted review, predictive coding, instead of linear review to get a production out the door, as there's just too many documents. In the past, when there was time for more dedicated linear review across all documents, then more of a privilege review could be done at that time. Often now that hasn't been done, and there have to be alternate workflow procedures for getting the privileged documents. Related to that is there's now more use of outside reviewers to do coding of documents, and they may have lesser case organizational knowledge for catching privileged documents, or they may be less trained or skilled than the attorneys handling the case. There's also a lot of issues with duplicates and near duplicates of documents that can be privileged, and we'll talk about that. There's also in-house, counsel, in-house and outside counsel, and attorneys are using email more and more, of course, and that means that the information is, more and more is being captured, and it has to be dealt with on the log. And then there's embedded emails and email chains that can cause issues. We'll talk about those. First, just go over the requirements of privilege logging. I'll talk about the Federal Rules of Civil Procedure mainly. The states, will vary some, but usually they follow this pretty closely. So the rule on this is Federal Civil Procedure 26B. It interestingly really doesn't talk very specifically about what's in a privilege log. That's in case law and other matters. But the main point there is that there's enough information to allow the receiving party of the production of the privilege log the ability to assess the claim off of what's been provided. So even though it's not in Rule 26, courts traditionally have required specific logging on a document-by-document basis, and this is a 2007 case that goes through the elements, and these are what everybody's used to: the nature of the document, the author, the date, the addressee, who received copies, reason why it was withheld. One particular problem of privilege logging is there's lots of case law that if you do it wrong or don't do it, that could be a waiver of privilege. And courts will, there's lots of courts, different opinions where they've said that just general conclusory assertions or failure to specifically give enough privilege information can result in a waiver. This is a draconian result and makes these privilege issues on large cases difficult to resolve with this hanging over one's head. There is a lot of case law language to the contrary as well, and that waiver is disfavored as a remedy for an inadequate log. There's better ways of dealing with it. Get into some specifics with the emails, why those cause problems. One issue is that the email body may be privileged or in an attachment not, or vice versa. And this causes complications as separating emails and attachment can be done in modern document management systems, but generally that's not a good idea because so much of the logic of them is built on being able to deal with these email families together. So it's possible to break or separate email families, and the family referring to the email and attachment together, but it's usually not best. There's different ways of dealing with this. One is to treat the entire email family as privileged if any part of it is. And the issue typically will be that the email body is privileged, but one or more of the attachments is not, and how to deal with that. To the extent that the attachments have been separately produced, that may be fine to include that in. So that's one approach that can be done. Another approach that is more comprehensive is to treat the email families together and then redact out the portions that are privileged, which typically is going to be part of the email body, and often the attachments are not redacted, or part of the attachments are redacted, and this can be a good solution. And then this will be logged as part of the privilege log, or sometimes a separate redaction log because of privilege, and that can be a good solution for dealing with these things efficiently. These issues at this level can be dealt with in ESI Rule 26 agreements along with forms of production, and that can be a good idea too. Another issue is email strings. These are multiple emails nested and embedded in text and we're all familiar with these as you have these long chains of emails being forwarded. And this should be distinguished from separate emails that may be related but were sent separately, that aren't part of the same document in a document management system. Those are easier to programmatically deal with and separately code. The emails that have been forwarded or embedded often are there'll be various things in the text that'll make those complicated or very difficult to separate out from different email clients. There's and the question of how to deal with these. There's what courts grapple with here is there's the danger of of a party hiding non-privileged information with a minor privilege component. So you get a very long string, a little of it's privileged, and you mark the whole thing that's keeping information out that should have been released in the production. The opposite concern is that if you disclose too much of this, that the privileged communication can come out indirectly or in pieces, and you just give too many signals to it. We see amazing email strings. People forward the emails, and the subject will change midstream. They'll go from talking to a birthday party to talking about something confidential or back, and then sometimes the header won't reflect what is actually the communication is about. As somebody replies or forwards an email and they don't change the header, so they can be difficult to deal with. Some courts suggest that these be separated out and logged, but because they come as one document, that's actually quite time-consuming and burdensome to do. So that's not done very much. Again, redaction of the privileged portions can be a good solution for that, similar as I was discussing before. There's an interesting New York state rule that deals specifically with these strings. This has been dealt with in some commentary in court cases and other states, but this is the most specific one that I'm aware of, and this came out just became the beginning of this year, was finalized. And what it says is an uninterrupted email chain will constitute a single entry on the log, but then there's requirements there. One is that the email chain represents an uninterrupted dialogue. The beginning and ending dates of all the emails, the range of the total emails of the dialogue is put in the privilege log. The number of separate emails within the privilege log is included. The names of all authors and recipients and their position in the company or case should all be on the log, enough to allow for a considered assessment of the privilege claim. So that's pretty detailed. That would be pretty difficult to do too, which is why I think often redaction is a good solution for that. But you can see that all the issues that can come up on this, that could be a hard standard to meet, particularly the one of an uninterrupted dialogue, and then how do you, what is enough information for a considered assessment. So it is interesting and helpful that it has a lot of specificity here, but then it also begs a lot of questions as well. But this is probably going to be influential on other jurisdictions. Another issue that's been receiving increasing attention is categorical designations, and that refers to a couple things, or can be. One of them is the practice of not only providing information as to why a document is privileged, but also putting it into categories that assists in court review or grouping them together. Still keeping with the document by document logging. A second use of that is that there would be certain categories that you would not need to log the documents on, and clearly that secondary one was the one that is more helpful in reducing the burden of logging. This is actually not a new idea. The Federal Rules of Civil Procedure in the 1993 comments referred to categorical logging, that there could be cases that are burdensome with voluminous documents, that they should be described by category rather than logged. And that was back in '93, so I think they certainly would have thought most of what we're doing today in litigation would meet that standard, I imagine. What sort of things can be might be categorically logged and not included in a privilege log. The idea here would be things that take a lot of work but are pretty uncontroversial that should be pulled out. And the New York Bar Association helpfully gave a couple examples of the sort of things that might be appropriate for this. One of them is communications between a party and its trial counsel. Second is work product created by trial counsel or non-parties after an action has commenced. And then a third would be internal communications, within a law firm, legal department, etc. And these are often the ones that require a ton of work to log and can be non-controversial, and they could be excluded. So that's the idea behind that. New York has a rule on this as part of that same rule, where they get into the specifics of it. They the elements of this rule is that there's, first off, that they have a preference for the use of categorical designations in their procedure now. Second is that that it should be done during the meet and confer, the Rule 26 under federal rule process. A responsible attorney for the producing party must provide a certification setting forth facts supporting each category, and that if a party resists a categorical approach and instead insists on individual document logging, that there's possible cost shifting, including attorney's fees for doing the privilege review. And then the rule also suggests that in complex commercial matters that parties consider hiring a special master to assist in dealing with privilege logging. So that's an interesting development with that, and I think we're seeing more and more discussion of this. In dealing with these categorical privilege logs, there's still the issue of waiver and case law that if you're not privilege logging, so typically one would want to deal with categorical privilege logs outside of New York with unless there's a local rules dealing with it with an ESI order or a negotiated agreement with the parties. Now we'll move into how to actually work with privilege logging in modern document review tools. We'll be using examples out of our Lexbe eDiscovery platform, but much of this would be the same in any other modern litigation review program. The first thing one wants to do in doing privilege logging is you want an integrated view of the document. So here's an example of how we do it in ours, where we've got tabs for different, where you can easily go back and forth to different views of the same document. So we'd show hits, from highlights from a search, which could be off a privilege search, the native or original. We use a PDF version, both a full document or a page-by-page view for the viewing document. Text that comes out of OCR. If you have a redacted version of the document, which could include redaction for privilege, and then an annotation for getting ready for depos. The couple different workflows for coding for privilege. One of them is on the document viewer. This would be tabs associated with the document viewer. You would go through, if you were looking at these documents one at a time, and you would code by privilege on the document. You can see on the lower left. And then another helpful feature you can see on the right is the entire email family has been identified with the attachments. And with the propagate coding, you can code the entire document at one time, including the attachments from the entire email family. Note there on the bottom that near duplicates of a document have been identified, and those can also be coded as well. We'll talk about near dupes later, so you pick those up as part of a linear privilege review. The second way of doing that is with mass coding, and on the far right shows a dialog box. I'm doing a mass coding, and there the privilege would be run off of searches, and then when you find documents and do a review of them, you would update them all at once, which would mean that you don't need to go in there and do the individual coding of the documents. One thing we offer that I'm not aware that anybody else has is we use a dual index, and that means that we index into our search both the extracted text from the native version of the document and also what would be created by creating a TIFF or a PDF of it, an image of the document, and using OCR with that. And then we put those both together into the search index. And it's very interesting that these two versions of the document pick up an amazingly different amount of information. The image or OCR version will capture anything that's imaged in the document, which there'll be a lot of information that have been in some form that hasn't been searchable previously with that OCR. The native extraction picks up a lot of information that isn't picked up in an image document. So an example of that would be often headers and footers in documents may not be picked up. Also, if a filter has been applied on, for example, on an Excel spreadsheet, and only a portion of that document was showing under the filter, that's the only thing that would make it into an image version of it, but the native version would keep the entire version. Can be similar issues with hidden text, hidden tabs. So for a comprehensive view of finding all privileged information off of search, we like having the ability to get to both sides of the text in the dual index. This slide shows creating an automatic privilege log from metadata. So in modern systems, when the documents come into the document review system, the available metadata will be extracted, including date sent, received, subject line, type of document. And that can go into a privilege log where a lot of the work's already been done. So and then that's really critical for getting through these large cases. So you can see an example here: the original emails and the names. The data has been extracted, and then you see at the bottom a copy of the privilege log can be customized and then downloaded and worked on. I want to mention a few things for redaction that are particularly important when you're dealing with redaction for privilege, but is also general. That if native documents are being produced, and that's done more and more these days, then the original natives should be withheld, as they can't usually be directly redacted. So if and usually the production is done in a PDF or TIFF. So the natives need to be flagged and withheld. If redactions are done on a TIFF version of a document, then it must be re-OCR'd to get rid of the redacted text. Similar issue with the PDFs. If PDFs are what's going to be produced, that text needs to be re-OCR'd on the PDF. And this will be a text layer within the PDF, and this has been an area where a number of people have made mistakes in the past with using inappropriate tools on that. Another thing that needs to be withheld is container files, and this is sometimes missed. That if you're redacting part of an email message, you can't give the MSG, which is the native version of it, because that would disclose it in the native. Similar with zips and other container files. Our system and many others should address these things in the logic of the system, but it's something to look at and particularly to build in time for QC procedures before your production to look at the redacted documents. Another thing I want to mention that's technology is NearDuplicate detection. So NearDup or NearDuplicate detection is a technology that looks for similar documents within a collection and groups them together. And there are easier abilities that our system has and others that get exact duplicates that are called hash duplicates off of a hash. and those will often be deduped as part of the collection procedures and processing. But there can be many versions of multiple versions of documents that are just slightly different that you'd want to review together, particularly for privilege purposes. And this can be, separately scanned versions of documents, Word or Excel documents that are only slightly different due to different save dates or minor edits. One document has a handwritten note on it, another one that doesn't. Versions of documents with red lines, that sort of thing. Emails can be grouped together if they're substantially similar. So the NearDupe grouping technology has a threshold of how similar the document should be. It's done on a text basis, and it groups documents together that more or less are about 50% the same, and then you can look at them together. And that's an important and helpful thing in general, but particularly with privilege. As you want to look at all the privilege documents that together at one time of a similar subject if possible. This is how this looks. Here, this is a view of 10 documents that are show up as being NearDupe as part of the NearDupe group 270 here on the right, and this shows that in this collection that 9 out of 10 of them were properly marked as privilege and product, but only one of them was missed. And this happens a lot, unfortunately, that counsel will be doing privilege review, and they'll get many versions of the document, but some of them will make it out the door, and can result in waiver in some instances. And even if there isn't a technical waiver, if there's a clawback, that information has still been out there, and the opposition may be able to address that information in some other form, and they at least know it's there to look for it. And that can cause a lot of problems in cases, and has in big cases. So this NearDupe technology can be very helpful as a pass of seeing that all the privilege information has been found on similar versions of documents that otherwise would be missed. Here's another view of that in the document viewer, that you can see you're looking at one document and you can see the multiple versions of it to get to them and look at them. And then here's a QC report that shows how many privilege groupings there are, all the privilege documents grouped by NearDupe, and then which ones are inconsistently coded. So one would go back on the data underlying this report and look at the groups that are inconsistently coded and determine if they should all be privileged or not. We're going to end up with some tips and recommendations on dealing with privilege protection and logging. One is to communicate with their opposing counsel early in document efforts. This really helps in showing the court that you've been taking this seriously and have made efforts to deal with things even if you weren't able to agree with everything. A Rule 26 clawback that's allowed by federal law, and many states will have another version is helpful in avoiding inadvertent waiver. Categorical logging, that can be done, can be very helpful, and generally you'll need to get an agreement or order to feel comfortable doing that. This is a point, but probably should be point number one, is just to make sure that you deliver a log. You do a log and you deliver. Many of the waiver cases have been when counsel just pretty much ignored the requirements of it and has gotten the court mad. The requirements are to do it at the time of production. That's a good idea. Sometimes that can't be done, and it should be done as soon thereafter as one can, and have reasons why it couldn't be done contemporaneous. It's an important point is to do it at least before depots, because once depots have occurred, then there's an argument that there's been a prejudice to opposition. As mentioned before, I think consider redacting email strings and attachments rather than wholesale withholding, as courts favor that. Negotiating specific provisions in an ESI agreement or a Rule 26 agreement early in the process is helpful with dealing with some of these issues, and special masters, can be used in complex cases. And let's see, that'll be my last slide. I will hand this back to Stu in a second, and then I want to thank everybody again, and then also, please feel free to contact me, gene@lexbe.com, if you have any questions or comments. I'll give this to Stu. Thank you.
Well, thank you very much, Gene, and thank you all for taking the time to participate in today's webinar. If any other questions come up, please feel free to contact us using the information that you see on the screen. You can also visit us at www.lexbe.com for additional webinars, articles, and other eDiscovery resources. Thanks again for attending. Have a great day, and we hope you'll join us again in the future.